Hey everybody, we're getting close to being done. This week we talk about the trial process. And I wish Dr. Fridella had done a little bit more thorough job in talking about each of the components of the trial and spend a little bit more time with evidence and presentation of evidence. And that's from my experience both as an attorney and as a witness. That's a pretty difficult proposition, is to know what you're going to try to present, how you're going to deal with witnesses, whether you're going to, on cross-examination, how that approach is going to be, how aggressive are you going to be. And I've had experience with some attorneys who are just, they're just brutal on cross-examination, to the point of being ridiculous. And I think sometimes they lose witnesses. But, with all of that, I'd like you to take a good look at it. In my face-to-face class, we do a mock trial. And the students have a chance to come in and then present a portion of a case. And it's kind of a fun deal. It's pretty stressful for the students, so maybe it's a good thing you didn't have to do it. But that gives them a better concept of the actual components of a trial, from opening statements to prosecution's case in chief, with direct examination, cross-examination, and then rebuttal, and redirect, recross. And then the defense case in chief, for each of the witnesses, direct examination, cross by the prosecution, redirect. And redirect is to deal with problems that may have come up in cross-examination. So, if something is an issue, as a witness, I always try to get with the prosecution before trial and sit down, so that they know, was there or are there errors in the report? Because writing, if you work in patrol and you're writing, 10 reports a night with an arrest report or two in the middle, you're going to make mistakes. I mean, it just happens. But if you get those things out on direct, that'll really be helpful for the prosecution to be able to mitigate any of those issues. So, with all of that, here's what I really want to talk about or get you focused on. And the first thing is the Ramos versus Louisiana. It's a case that's before the Supreme Court now. And what Ramos is about is, does the 14th Amendment require that a verdict be unanimous? There, an earlier case, Apodaca versus Oregon, was a 1978 case, and that made unanimous verdicts required in federal trials. Now, when you get into 350, you're going to see that the discussion about whether or not, how do you get the Fourth Amendment to apply to the states? Because remember, the Constitution's about the federal government. It's not about state government, except for the 10th Amendment. And everything else is about how the federal government runs. And it wasn't until Mapp versus Ohio, and a lot of you had this in your last short writing assignment, how Mapp applied, and I can't even remember what the what the issue was, but Mapp wasn't relevant to that discussion board. Mapp is about the Fourth Amendment being applied to the states through what's known as the incorporation doctrine of the 14th Amendment. So that's the issue in Ramos. 2 states allow non-unanimous verdicts, Louisiana and Oregon. And the idea is, Apodaca said that it was that the unanimous verdict would apply to the federal government, and now there's an attempt to get Ramos to stand for unanimous verdicts, the Sixth Amendment rights, unanimous verdicts, and the 14th Amendment to apply them to the states, which will change how Louisiana and Oregon do conduct their trials. The next big part of this week is the idea of jury selection. And there is a ton of litigation in the appellate level about how jurors are either selected or rejected. If you've ever been to or gone through jury selection, you've been part of a panel, jury box method's probably the most common, where 12 people, 13 people are called up. They sit in the jury box. They go through each person. Each person talks a little bit about themselves. They have a series of questions written out from the judge. They're posted on the wall. Then the person will go through and answer each of them. Are they married? Do they have children? Where do they work? How long have they worked there? The kind of demographic kind of questions. And then the attorneys will then have a chance to question each of the potential jurors. And that the purpose of that is, one, to fill a jury box for trial, but two, I think a little bit of introduction to the case and ability of attorneys to gain rapport with the jurors. So kind of a twofold goal there of jury selection. Here's where the controversy comes up, in a case called Batson. And Batson was about racial disparities in jury selection. And you see that frequently as an issue. In the book, Dr. Fradella talks about a case to extend the Batson challenge to sexual orientation. And that's an interesting proposition. So when the attorneys talk to people in the jury box, they have two types of challenges. One is a challenge for a cause. The other is known as a peremptory challenge. Peremptory challenge doesn't need cause, but that's the one that doesn't need cause, but it causes us. That causes us the problem in that attorneys will be, or the jury selection process will be challenged because of or with the concept that persons were not selected because of their race. And very highly litigated. You see it constantly. See it all the time in there. So for cause, if the attorney can say, Your Honor, I wish to thank and excuse juror number 4, and gets challenged on that, the juror number 4 has said that they would not be able to deal with this case in a fair manner. They have prior family members who were killed by drunk drivers, as an example. So that would be a challenge for cause. And those are unlimited, but they get more and more difficult as jury selection drags on. You can see where, jury selection could take forever, and that's the last thing the judge wants. The judge wants to come in, sit down, bada boom, bada bang, let's go, and then start the trial. That's the idea of that. Now, the peremptory challenge, is one that can be exercised with no direct discussion as to why the person's being eliminated from the jury pool. So those are limited. Misdemeanor, I believe, California is 6, felony it's 19, 15, and then death penalty is 21 peremptory challenges. You can see where we're in a death penalty case. That's going to be a long day. I mean, jury selection is going to be a long day. But there's a lot of people that that have problems. They are not death penalty qualified, meaning that they could not vote to put somebody to death. And that's another challenge that has been brought up regarding death penalty, another approach to the many faceted approaches on death penalty. So that's all I want to talk about this week. Everything else is laid out pretty well in the book. So I just wish there was a little bit more about the trial process. But all that being said, hope you have a good week. And